Okay, good morning.
Good morning.
Good morning again.
Here on the case of Simone versus Ratner, 19-3269. This argument is being live streamed so the public can watch it, and we will go ahead and proceed. Mr. Byrd, you may proceed with your argument.
May it please the court, Jeffrey Byrd, I represented the plaintiff in both trials below as well as these appellate proceedings. Would ask for 5 minutes in rebuttal time.
Okay.
Two distinctly different issues are on appeal in this case, but the theme is the same as this morning, which is whatever a court allows is what will continue to occur. This is a case where the subsequent denied a request to impose attorney's fees for Mr. Goebel having caused a mistrial of the first trial of this case. And the appellate contends that the failure to award sanctions is the equivalent of, number one, penalizing the innocent elderly plaintiff who did nothing to cause the mistrial. And number two, it actually rewards defense counsel who is enriched financially by the insurer for retrying the case a second time. This is a case where Judge Munyon presided over the second trial, but she was tasked to review the trial proceedings of the first trial judge, Judge Renee Roach. But Judge Munyon expressed that she declined. Yes, Your Honor.
I'm sorry, before we get to the merits of the argument, which I think is what you're about to proceed and talk about, can you address the timeliness issue that Mr. Goebel brings up? And specifically, do you have any authority to support your argument that the generic request made for fees in your motion for mistrial is sufficient to satisfy Rule 1.525?
Specifically, the plaintiff's motion for mistrial was entitled Motion for Mistrial and Sanctions, and the sanctions expressly sought were attorney's fees and costs for having caused that mistrial. The argument advanced by Mr. Goebel was that because there was a separate specific motion for attorney's fees filed more than 30 days, I think it was 40-something days after the initial judgment was entered, that somehow made that motion deficient. The argument advanced by myself to Judge Munyon was that first off, that rule requires that the motion be filed no later than 30 days. It does not prohibit somebody from filing any motion before the entry of a judgment, which plaintiff contended
Mr. Byrd,
did
that motion ask for attorney's fees to be awarded specifically against Mr. Goebel, or just generically award attorney's fees?
I don't have that motion in front of me. I would like to give you a specific answer, but feel compelled to just refer to the record.
The where therefore clause says the award of attorney's fees and costs for having to retry the case. Do you think that's sufficient under the rule? If it didn't specifically name, I'm sorry, go ahead, Mr. Byrd.
No, I do believe that was sufficient because A, that is a motion, that B, does seek attorney's fees and costs, C, for the mistrial having been occasioned by Mr. Goebel's conduct. But there's an additional argument separate and apart from what I've already advanced, which is the argument advanced is well, the motion wasn't filed within 30 days of entry of the judgment. But interestingly, in this case, there's a subsequent judgment which was entered, and I'm looking for it right now, on November 7, 2019, an amended final judgment with respect to the verdict. So this motion for attorney's fees was filed well before then. In fact, indeed, many, many, many months before that final judgment was entered on November 7, 2019. So arguably, this motion could have been filed even after that amended final judgment had been entered, in as much as that is the final judgment with respect to the issues in this case.
All right, let me talk to, we started to talk a little bit about this and then decided it would be better to speak about it, in this case, which is the the filings over the last couple days. Some of it related to an order that occurred obviously subsequent to this case, and it wasn't part of the record. And yet you file it as a motion for supplemental authority. It doesn't seem to me that that's a motion for supplemental authority. That's you're just filing things and you're not seeking leave of court to supplement the record.
Right. You did ask me that question this morning, and I was kind of taken aback because I wasn't entirely sure I understood. Now that we've had the opportunity of a break, I went back and looked, and I believe what Your Honor is referring to is on August 11, 2020, so 9 months ago, not this weekend, 9 months ago, filed a notice of supplemental authority that simply attached an order that is directly on point to the issues that are on appeal here, which
That's
was
not supplemental authority is case law. If you wanted to supplement the record, you file a motion to supplement the record.
Well, the rule actually says any legal authority, and what I had attached was a ruling of a judge 9 months ago that is directly on point as to the issues in this case, which was the awarding of attorney's fees for a mistrial caused by defense counsel's behavior at the first trial. This weekend, what was filed was not a pleading filed by the appellant,
Mr.
but rather.
So I understand that.
Okay, and so I wanted to be clear, I wasn't the one that filed these last minute pleadings. And indeed, when I filed the supplemental authority, it was filed even before the reply brief was filed in this case. The supplemental authority was August 11. The reply brief was September 28 of 2020. I hope that addresses Your Honor's question. But getting back to, I guess, the issue before the court, and it's two distinctly different issues. And I candidly acknowledge that one has nothing to do with the other. They're both very different. But with respect to the denial of the attorney's fee motion, it was made by a successor judge who, incidentally, I have a great deal of respect for Judge Money, and I hope that nothing that is said in my brief or an argument today suggests otherwise. But, to use a sports analogy, even Tom Brady throws an interception every now and again. With respect to her ruling, she was very clear that she wasn't going to rely upon the rulings of Judge Roach. Well, Judge Roach made some express findings with respect, and I counted 11 different examples of Judge Roach as briefed by the plaintiff, and there are yet more that weren't briefed, by the way, where Judge Roach took issue with Mr. Goebel's continual reference to an inadmissible record, knowing that it was inadmissible, knowing that it had been objected to by the plaintiff, but nevertheless was utilized multiple times to impeach the plaintiff, her husband, and the only treating doctor that testified live for the plaintiff. We have a rule of professional conduct, 4-3.4E, that says a lawyer shall not in trial allude to any matter that will not be supported by admissible evidence. The Judge Roach came to realize that the document that Mr. Goebel continually utilized throughout the first 3 days of trial was never going to be admissible, was objected to, had nothing to do with the witnesses disclosed in this case, nor the evidence disclosed to be used in the case.
That's the Enfeld letter, correct?
Yes, sir. A letter by a different doctor to a different lawyer relating to a different matter. And then from that, it was extrapolated.
Bird, I'm going to ask the same question of Mr. Goebel, but is there anything in the record as to whether the plaintiff had either sued or received any type of settlement for the 2006 accident?
The record is very clear that she did not. Yet there were repeated references to her having brought a legal claim. That was the argument advanced by Mr. Goebel multiple times in front of the jury.
Isn't it true there are only 2 references? Do you think there's more than 2 references in the record to a legal claim?
I have it in my notes. Let me check. I have the record 38-15 reference to her having brought a prior legal claim. And then I have in the record at 3871 through 72, at 5474 and 5659, the references to her having brought a prior legal claim as a result, and made it a feature, by the way, referenced that she had received extensive medical treatment, which, by the way, there had been a 2-year gap in the lack of care and treatment before this accident. But the statements expressly made were that she had received extensive care and treatment, and then had her lawyers obtain a narrative report, an impairment rating report from this Dr. Imfeld for purpose of utilizing it in a legal claim. That was the exact statements made at that trial, which is, again, numbered among the 11 things that I've identified with Judge Roach. She used words that was astonishing, that it bordered on unprofessional, that it was a misrepresentation. And she actually was stronger in her language than I was. When I used the term fast and loose to describe what had occurred by utilizing it, she said, well, you're being far nicer than I would be. I would contend that misrepresents and is unprofessional. Those were the words that Judge Roach chose to use in describing what she came to learn was being done at that trial. Almost prophetically, I had made an argument at the end of that motion for mistrial hearing that I believed Mr. Goebel was attempting to recuse her before she made a ruling on the motion for mistrial, so that it would deprive any court record of having an express ruling granting a motion for mistrial wherein the plaintiff was seeking fees. And I remember I made the argument to include references to the claim for fees and costs for that mistrial. And Judge Roach almost was astonished that I would be concerned that an argument would be advanced later that Mr. Goebel wasn't the reason for that mistrial. And she addressed me and said, well, I don't know how anybody could make such a contention given the record in this case. And of course, I'm paraphrasing, but I did quote exactly what she said in the record on appeal, or in the briefs relating to the record on appeal. So yet here we are today, and that's the very thing that's being advanced, or was advanced to Judge Munyon. An argument was advanced to her that she should not award attorney's fees. And so as to that issue, I want to make sure I was both clear in my brief and clear today that I do understand that traditionally these types of matters are viewed on an abuse of discretion standard, with the same judge who had presided over the same trial having made those determinations based upon that trial's view of the presentation of evidence. But here we have a unique setting, and I cited about 5 or 6 cases in the brief that stand for the position that when a successor judge is in no greater position than the 3 of you would be, that judge has no superpower. She's not a 4th judge on this panel, nor is she, I guess, in essence, one judge standing over the 3 judges who preside over her.
But you understand, Mr. Bird, that it's an interlocutory order so that she's not bound by it as well. You understand the law on that, right?
Except the difference is that she expressly stated that she was not going to review or consider the findings of Judge Roach, and she believed that she couldn't do so because Judge Roach had been recused. But Judge Roach had not been recused because she made improper findings of fact and rulings of law. She actually became recused by this court on a procedural argument that had advanced by Mr. Goebel on a lack of clear. It's not that Judge Roach was wrong, but Judge Munyon stated she wasn't going to review the findings of Judge Roach, which then puts this court in the position, I believe, of doing a review de novo. This court has the ability to make a determination, and the appellate contends should remand this case for a review. After a determination of entitlement to fees based upon this court's de novo review, and remand it back to the trial court for purposes of an evidentiary hearing as to the amount of the fees and costs. Otherwise, as I said to begin, It's a penalty to the innocent elderly plaintiff who did nothing wrong. It's rewarding somebody who is engaged in this intentional, repeated conduct to the detriment of the court system and the valuable time of judges and juries and our court administration and having to try cases. I see that I'm into my rebuttal time and I haven't even addressed the second issue, but to be succinct, I briefed with respect to the second issue that the judge had already made the proper ruling. In January of 2009, she entered an order denying the motion for collateral source set-off by the defense. But then they filed an unauthorized and improper motion for rehearing that did not cite new law, did not cite new evidence, but yet resulted in another year's delay of this case and resulted in the court in the absence.
You seem to be claiming error, not for the ruling on the motion. Well, I mean, you do on, but just for the setting of a hearing on the motion for rehearing. You think that's error?
It's actually three component parts, and you're correct. All three of those arguments advanced by me in the brief are applicable here. A, there was no new facts, no new law, no basis to grant a rehearing in a setting where the evidence and the argument had already been presented.
What about a motion for rehearing that simply says, Judge, you were wrong on your analysis, and we'd like you to reconsider. We get that all the time.
And respectfully, that's not what occurred. That is not what occurred. What occurred was a re-argument of the same evidence that had already been presented and ruled upon. There was even the same Woodhausen case that was presented the first time that was argued the second time. So there was, and indeed the court even stated that she was going to, with respect to the arguments advanced at the rehearing, weigh the evidence. So this was nothing more than a continual re-litigation of an issue that had already been litigated and ruled upon in January of 2019. I understand why lawyers want to re-argue facts and law and evidence, but there was no new facts, no new evidence. And indeed, the reason why there was a subsequent hearing after an initial motion for rehearing was the court determined that she needed to have evidence presented to her. And when we go to the court 6-8 months later, there is no evidence, there is no testimony, there's no affidavit. There wasn't even a single deposition conducted in the interim time period for there to be new evidence presented to the court. I see I've only got 2.5 minutes left and I talk too much, so I'll wait to reserve the remaining time for rebuttal. Thank you.
All right, thank you. Mr. Goebel.
Yes, Your Honor. I think the first question to address is the standard of review. It is an abuse of discretion standard. This is not a successor judge ruling upon a cold transcript who did not have a firsthand view of the proceedings. This is a judge who reviewed a transcript based upon a different motion than the one it issued in this appeal, and she had an evidentiary hearing which she conducted. So she reviewed and ruled upon a motion filed after the second trial. The plaintiff did not file her motion.
Mr. Goebel, let me ask you, is it safe to assume you watched the oral argument from the earlier case?
No, Your Honor, I did not. I was preparing for this argument.
All right. Well, you understand that there was a mistrial granted in that case as well, right?
In the case from this morning?
Yes, the case was tried twice. There was a mistrial that occurred, and it was tried again. And in this case, a mistrial, and it tried a second time, right? You know that.
That's correct, yes.
Now, I can tell you, I haven't taken a poll, but you've got 3 judges on this panel, and I'll bet that you equaled in these 2 cases the total mistrials that occurred in all of the cases that the 3 of us have heard. And the point I'm making is that it appears that there's a pattern in your cases of conduct that necessitates the granting of mistrials, and I'd like you to address that.
Well, the case from this morning, if I recall correctly, and that was years ago, and I did not prepare for that, case, that was a case where Judge
LeBlanc.
Yes, thank you, Judge. I can picture him and not I'm drawing a blank in his name. But yes, he pointed to the conduct of both counsel in the first trial. And
Well, certainly, Mr. Goble, you're well aware of your reputation among the judges, just as we get reputations as well. But you certainly are aware of your reputation among the judiciary, are you not?
well, Judge, I will say this. I believe zealously in my client's causes. I do everything to.
No, that's not what I'm asking you.
Your Honor, I do understand that there can be a perception. And I also understand this, that if there are rulings that are made that have errors in them, it doesn't matter that the rulings have errors in them sometimes because they just snowball. And one of the cases that you may be aware of, because it came before this court, was the Swanson case. And there was a motion for mistrial in that case that was granted. And the order, unfortunately, said that I had violated a court order. And I came before this court and I pointed out to this court that there was no violation of the court order, that there was never one identified by the plaintiff in that case. That even when they had outside appellate counsel review the record in detail, they never identified one.
All right, well, let's talk about the specific error in this case. Can you cite to anything in the record that supports the fact that there was either a lawsuit or a settlement of the 2006 accident?
I don't think that I ever made a reference to a lawsuit or a settlement.
You absolutely did.
Saying,
here's how you phrased it. You phrased it, the question as to whether she made a claim for injuries.
Correct. Yes.
Okay? What evidence do you have to support that?
There was a letter from her prior counsel that
said what?
Where her prior counsel wrote and said that they were representing her with respect to her injuries from that accident, and that they were requesting that Dr. Imfeld issue and I don't have the letter in front of me, I can find it, issue an impairment report. I can find it, Judge. So there was the first letter, and then there was the second letter. That letter was on September the 15th, 2018. This is a letter that was entered into evidence at the hearing before Judge Munyon. And
was it admitted in evidence at the trial?
No, it was not.
Was it an admissible document?
And Judge, no, I would say that that document, well, it could have been admissible, yes.
Yeah, did you list the doctor as a witness?
The doctor at one point was listed as a witness, and then we had a stipulation that records custodians would not be called at trial. And so based upon that, Your Honor, the records would be admitted as business records.
Well, you agree that you can't put in a business record and just on that grounds alone and try to act as that's a conduit for an opinion from an expert. Would you agree with that?
Well, Judge, it depends. And in fact, this court, there's the Heckford case that I cited to the court below. But in fact, and I hesitate to reference it, but it was a case that I found in preparing actually last night that this court cited, which is this court cited to the Heckford case in a case called Kelly versus State Farm from 1998. And in fact, that case does reference using
was that in your brief?
Expert.
Was that case cited in your brief?
It was not, Judge, and I just said it was
Then
not.
did you do a supplemental notice of supplemental authority?
I haven't, Judge. I
Well,
literally
then you know you can't talk about that case.
Yes, Your Honor, that's correct.
All right,
Let me
then
ask
don't
you,
do.
I'm sorry, go ahead, Judge.
Then don't do it.
Yes, Your Honor. So, but I could reference to the Heckford
Mr.
case.
Goble, do you believe there's a difference between considering and even going to a lawyer to see if you have a legal claim and actually making a legal claim?
Well, Your Honor, when a personal
Well,
injury,
do you believe there's a difference
is there a difference between making, I would say that
between
when
considering one and going to a lawyer and saying, do you think I have a claim?
I think that-
and actually making a legal claim.
I think when a client presents a claim to either an insurance carrier or to the other side, where there actually gets filed as a lawsuit, that is making a claim for injuries relating to that accident. That's a legal claim. So yes, and I think there are cases that I cited to the court below. I think there's Zabner and Zinchek.
But at the time you said she had made a legal claim, did you have any evidence in the record to support that? Because that letter from Imhoff wouldn't say she made a claim.
No, what I had to give me a basis to ask that question was the letter from the plaintiff's attorneys that was contained in Imfeld's records. And Imfeld's records clearly showed that she was represented by an attorney, that he said he represented her based upon the accident, the bus accident from 2006, and he was requesting that Dr. Imfeld provide details regarding her maximum medical improvement and her permanent impairment rating and restrictions, future and present. So clearly that would relate to a legal claim that she was making for the injury.
That would suggest that she's considering making a legal claim, wouldn't it?
Yes, it strongly would.
All right. Does it mean that she had made a legal claim?
It doesn't necessarily mean that she went and filed a lawsuit. It doesn't.
So what were your words to the jury during your opening statement?
I can find it, Your Honor, but
I think it was she made a legal claim.
Okay. Well, and Your Honor, that's what I believe that the evidence would show. And in fact, Judge, if I'd been permitted to ask the question at trial, and Mr. Simone said he didn't think she got anything from it, something to that effect in the first trial. So was there a basis to go ahead and ask the question at trial if she made a legal claim? If I've got this record, here's what it boils down to in this case, Judge. And I do want to get to.
Did you ever take her deposition?
Did I ever take Ms. Simone's deposition?
Yeah.
I don't remember if I personally did. I don't think I personally took her deposition, but certainly my firm took her deposition. Yes.
Okay.
So
let me ask you this. You started to get into that you zealously represent your clients. Do you think as an attorney that you have other obligations to others besides zealously representing your client?
Yes, certainly, Your Honor. Absolutely.
What are those?
Yeah, certainly I have an obligation to work within the bounds of ethics and professional responsibility to do those things to the best of my ability.
In the oath now, and this goes really to both of you, but in the oath now, it says you promise civility to the other counsel. How do you think you and Mr. Byrd have fared in that regard?
I would be very frank. I would say it has not been pleasant. And if you look also, Judge, and I think this is important, and I do want to make this point. Look at the briefs in this case. Look at the filings in this case. Look at the filings in the other cases that I've had with Mr. Byrd and the motions that he's filed. And look at my filings. Do I ever make any personal attacks? Do I ever call names, directly or indirectly? Do I ever do any of those things? And then look at the filings, Judge. I don't do that. So absolutely not. But Your Honor's question was, has there been civility? I would say very unfortunately, no, there has not been. It is.
I think Judge Kest made some remarks about that, didn't he? As far as your discovery.
Yes, he did. And what was interesting too is, and I looked at that order briefly yesterday. If you look at the things that he cited to, and again, you're saying be civil, but if you look at the actions, the facts that are cited to in that order, those are all facts that my firm had to address based upon those are actions that Mr. Byrd took that were cited by Judge Kest.
And this question I'm making is really directed to both of you, but we sit here, we have a order from Judge LeBlanc, as far as a mistrial because of the conduct from the parties. We have a Judge Kest saying the worst professionalism and cooperation he's seen. What do you think, if anything, an appellate court can do to try to prevent that type of conduct from continuing, whether it's by you or Mr. Byrd or any other attorney?
Your Honor, I think the appellate court needs to look very specifically at the standard of review. I think you need to, it's not my job to tell the okay, but you're asking me.
Right.
So one of the things, and you've asked me, you know, you've seen other orders, okay? This is one of the things, and I want you.
I'm talking about just in this case. We
Yeah.
don't even have to go to other orders.
Right, but you did ask me about that. And, you know, and it all comes in one big ball, right? All this is together in one substance, one container, so to speak, one bucket. But you have to look at the underlying facts. For example, in the Swanson case, and I'll go back there. There was an allegation I violated an order. But even on a hearing where there was a motion for sanctions in that case by the plaintiff's attorneys, and I cross-examined the plaintiff's attorney and said, what order was violated? Name an order that was violated. Please name an order, any order, and she could not do it. So it was not only the plaintiff's attorney that couldn't identify one, the appellate attorney that couldn't identify one, and there was never one identified in the court order, but yet this court order persists, and it snowballs, and it's hurtful, it's damaging professionally, it's damaging personally, it's damaging emotionally, it's awful. And yet that snowballs, and then that comes before another court, and now that comes before
you think, Mr. Goebel, that you're devoid of responsibility for that?
For the Swanson order?
No, for you know, the what you call the snowball effect. I mean, my goodness, Mr. Goebel, you know, case after case after case, you have mistrials. It's not isolated. It appears to be a regular occurrence, and it's not in the ordinary course of what we see. It's, you know, but you don't appear to take any responsibility for it.
Judge, I do want to tell you that I do. I mean, I am deeply troubled and hurt by these personally and professionally. And I disagree with the perception, and I have to do everything I possibly can to work very hard to make sure that this does not persist. It is an awful situation, and it is a situation, just like Your Honor said, that snowballs. And if there are errors in orders that I can't correct, that perpetuates the snowballing effect. You know, there is a situation where, you know, you reference this notice of supplemental authority, which is not a supplemental authority. Clearly it was filed to do just what apparently is done in this case, which is to influence Your Honors. So, and I recognize that that had not been corrected this weekend. I said, well, that obviously needs to be corrected, that motion for rehearing was filed, and there's still a pending order in that. But if you look at the motion for rehearing on that and look at the underlying order, you know, you can see that there are plain errors on the face of the order. And yet, but yet then that gets filed as evidence that there was a violation of an order. So yes, that is a extremely hurtful, troubling, difficult situation that I have to work very hard to make sure does not persist. I have to make absolutely certain that everything is done more.
In this record, with the transcript of the dialogue between you and Judge Roach indicate that she had significant concerns about your actions in this case, in the first trial?
Judge, yes. And here's what, this is important, okay? This is a fact that cannot be overlooked by this court, okay? What was the most important thing that happened in that transcript? The most critical question that was asked by Judge Roach, and what did she believe in that case? And this was at page 3842 of the record, okay? And Judge Roach asked Mr. Byrd, because remember, I was ambushed by this motion in the morning of that Monday morning after trial. I had no idea this was happening, okay? So didn't get a chance to review any of the transcripts, didn't have a chance to review. And by the way, and I'm gonna get to this, but this record is incomplete. And one of the incomplete aspects of this record that's so important is the deposition of Dr. Pruitt, which also gave an additional basis to be asking about this permanent impairment rating. But that is not here. It's not before Your Honors. But what's the most important, most critical question that was asked?
If it's not part of the record, why are you talking about it?
And I'm not, Judge. I'm just saying that the record is
You
not.
did. Yeah, I mean, you just did.
Well, simply mean to say that the record is not complete here.
All right,
Well,
but I'm asking you about Judge Roach's comments. Would you
Yes.
agree that she indicated concern for your conduct, and you were in the midst of responding that yes, the most important question? So let me go ahead and hear that.
Yes, the most critical question that she asked in the motion for mistrial was as follows. And she asked this of Mr. Byrd. Well, let me ask you this question. When your client takes a stand, Mr. Goebel would cross-examine her and say, isn't it true that you received a permanent impairment rating from Dr. Imfeld in December of 2008 or whatever it was? I'm quoting her. And she says, he never said that to me. And he tries to refresh her recollection with that document. She says, I don't know what that is. And Mr. Byrd says, exactly. Now, we know that was not the case. We know that when we asked Ms. Simone in the second trial if she was aware of the permanent impairment rating, she
That
was.
assumes that she gained no new information between the first trial and the second trial, though. Would you agree with that?
No, I don't, Your Honor. I don't agree with that. I believe strongly
No,
that.
was there anything in the second trial or any evidence in any record that indicates she had that knowledge before the first trial?
There's no knowledge that she didn't have it in the first trial because the first trial didn't proceed. I would suggest strongly, Your
Rules
Honor,
talk about referring to things that are in evidence or likely to come in. I mean, it's almost like you're arguing, well, there wasn't an order in limine prohibiting me from doing that, but you agree you're not supposed to refer to matters that are in evidence and that are unlikely to come in evidence.
the question would be, I believe the appropriate question is, Judge, did I have a good faith basis to ask Ms. Simone if she had obtained, if she was permanently injured from the bus accident? Did she obtain a permanent impairment from the doctor that treated her from the bus accident? Did I have a good faith basis to do that? And obviously, Your Honor, I believe that I did because I had the impairment rating from Dr. Infeld. And then not only that, but we had the
You used a permanent impairment rating that you had no way to get into evidence.
Well, there was.
You didn't list him as a witness. You didn't depose him. You didn't present his deposition. You had no way to get that into evidence, and yet you went ahead and asked the question.
Judge, if she knew about the permanent impairment rating, and she knew about that, that was admissible.
No evidence that she did.
Well, we do have evidence. We've got the fact that she knew.
In the second trial.
Testified to it.
In the second
She
trial.
testified to it. There's no reason that anyone would believe that her testimony in the second trial would be different from their testimony in the first trial. It's the same trial, the same facts. If she knew about it, she knew about it. So if I was able to ask her in the first trial, just like I did in the second trial, Ms. Simone, did you have a permanent injury from the first accident? She certainly would have had to concede that because she knew about it. So, Judge, I think there's one more important point, and hopefully this.
The thing, though, is that you didn't talk about it in terms of injury. You talked about it in terms of claim. It's one thing to say, you were involved in an earlier accident and you were hurt in that accident. Were you not? That's one thing, but that's not what you did. You talked about it in terms of a claim in after the first accident.
Your Honor, I think that what you're referencing is where I cross-examined the plaintiff and she admitted that she had a permanent injury and a permanent impairment rating. I don't believe I cross-examined her at all about her legal claim because the court would not allow me to do that. So
but you already advised the jury of a legal claim.
Okay, in the first trial, are you talking about in the first trial where there was the opening statement, and then of course I had the evidence or the documents that showed that she consulted with a lawyer, that they asked for an impairment rating, which is in fact, and I think everybody acknowledges that a permanent impairment rating is used for the purpose of a legal claim.
That doesn't mean a legal claim was made. That's the whole point. All right, your time is up. Rebuttal, Mr. Byrd.
Yeah, as to a few points, I absolutely disagree with the statement that my client knew of this impairment rating letter before this first trial. There's absolutely zero record evidence to support that statement. There wasn't any evidence to support it at the time of trial. There's not any evidence to support it today. In fact, that letter was written months.
Her lawyer, obtains a letter from a physician giving her an impairment rating, and you're suggesting that, oh, she's not going to know about that? Really?
That's exactly what I'm stating, sir. And the reason being is that letter was written months after she had last seen that doctor, and according to that office visit, she was doing well. And the question that was asked by Mr. Goebel of her husband, Mr. Simoni, was to the effect, and I am paraphrasing, the record is very clear. Were you aware that when she saw her doctor, he gave her an impairment rating? That was a factual impossibility. That letter hadn't even been written until 2 or 3 months after she last saw that doctor. But yet, he asked the question in the presence of the jury of a husband who he has no good faith basis to even believe was at the appointment with her. And he does it so that he can continually perpetrate this notion of plaintiffs who are dishonest, who are bringing fraudulent claims, who are engaging in collusion with lawyers and doctors. And this is the continual theme that occurs trial after trial after trial.
Well,
now, Your Honor asked a specific.
We had a case not long ago where, you've got the same radiologist, you got the same surgeon. I mean, it's ripe for cross-examination.
Well, I want to focus on the record before this court, but as it relates to Your Honor's question, you asked with respect to Mr. Goebel, did he list Dr. Infeld? And the answer was he did initially list him, but then he expressly withdrew him. This notion that he withdrew him after records custodians were waived is nonsense, because that's not what happened. But that was never going to be a witness. And this lawyer was never going to be a witness. And this letter was never coming into evidence. It was expressly objected to by the plaintiff. Lastly, and I say I'm over time, but since your honors have asked questions, Swanson case was affirmed by this court. That's a case where Mr. Goebel's conduct caused a new trial. Plotkin was affirmed by this court. That's a case where Mr. Goebel's conduct caused a new trial. And as recently as just a few weeks ago, the State Farm versus Bergman case was affirmed by this court, also a case involving Mr. Goebel necessitating a new trial. All three of those cases have nothing to do with Mr. Berg. I was never involved, but they all show, just as the case this morning showed, that I agree with Your Honor, there does appear to be a pattern in Mr. Goebel's cases of conduct by him that necessitates either mistrials or new trials. And the time has come that a court take action to stop it. And I submit that until such time as a court does something about it, whatever you allow is what will continue to occur. So I'm over my time, and I thank you all for your time.
Understand, that there are standards of review at an appellate court, and the fact of an affirmance is not necessarily a stamp of approval on the conduct of counsel. It's more in line with what our job is, our responsibility as a court of correction of error, and the standard of review. But that said, do you think that you have any responsibility in this case for the conduct and the lack of civility between the lawyers? Do you bear any responsibility?
I will say yes. And Judge Kest addressed that. And to be clear, Mr. Goebel and I both went to a bar professionalism committee upon Judge Kest's referral. And that was a moment in my career that I'm not proud of, but yet I took accountability. And there is nothing in this record as it relates to the first or the second trial that has ever been alleged that I engaged in any unprofessional behavior beyond that point in time. So I do own that. I accept it. I have endeavored to conduct myself in a manner consistent with our rules of ethics and professionalism, but respectfully, Mr. Goebel continually does not, and it's demonstrated by the record, and I'm just going to let the record speak for itself. Unless there's
thank you
anything
both.
further, I appreciate everybody's time today.
All right. This oral argument is
Thank you.
concluded. Court is in recess.